On July 1, 2024, the Indian legal system executed a massive statutory transition. After 164 years, the Indian Penal Code terminates, replaced by the Bharatiya Nyaya Sanhita. Technically, this is a repeal. When a legislature repeals a statute, they declare it legally dead, striking the text from the books and removing its authority to govern. This creates a mechanical problem known as the extinction paradox. Imagine an individual commits a offense on June 30th under the old code, but the crime is not discovered until July 5th. The state cannot prosecute this individual under the new law, the BNS, because applying a criminal statute retroactively violates fundamental constitutional rights. Logically, the state also cannot prosecute them under the IPC, because as of July 1st, the IPC no longer exists. The legal framework defining the action as a crime has been erased. Without a structural mechanism to bridge this gap, every statutory repeal would create a window of absolute legal immunity, disrupting the continuity of the state. To prevent this, the legal system relies on a meta-law designed specifically to manage statutory transitions, the General Clauses Act of 1897. This act functions as the background operating system for all central legislation in India. It dictates how surface-level statutes must behave during transitions. Section 6 of this act contains a protocol that triggers the exact moment a central act is repealed. Section 6 intercepts the repeal, constructing a regulated afterlife for the dead statute. It ensures that while a repealed law loses the power to govern the future, it retains the authority to settle the debts of its past. Section 6 is a departure from the Old English common law default rule. Historically, when a law was repealed, courts treated it as if it had never existed. This obliteration rule was chaotic. The moment a repeal took effect, pending trials collapsed and legally accrued rights evaporated. Section 6 explicitly overrides that old default. It dictates that a repeal shall not affect the previous operation of the dead enactment or anything duly done under it. This applies automatically unless the new replacing statute explicitly states a different intention. If the legislature wants a total erasure, they must write that instruction directly into the new law. Barring that instruction, Section 6 acts as a temporal sieve. The statute itself stops at the termination date, but specific threads of consequence pass through into the new era. This transforms a repeal from a hard deletion into a controlled, selective preservation of legal reality. The statute defines which threads pierce the barrier. Clauses A and B dictate a repeal won't revive dead laws or invalidate completed actions. Clause C preserves accrued rights and obligations. Clause D preserves liabilities and penalties incurred for past offenses. But resolving our opening paradox depends entirely on Clause E. Clause E protects all ongoing investigations, legal proceedings, and remedies tied to those past rights or penalties. Revisit that June 30th crime discovered on July 5th. Under Clause E, the investigation and trial proceed as if the IPC had never been repealed. The courts apply the old definitions and the original sentencing guidelines. The state prosecutes that crime using a zombie statute, kept functionally alive by the General Clauses Act just long enough to close the file. In practice, statutory drafting is often messy. Legislatures might write transitional provisions in the new law that clash with the General Clauses Act. To resolve these deadlocks, judges rely on the Latin maxim, generalia specialibus non derogant. This means general provisions must yield to specific provisions. If the new BNS contains a specific rule for a certain type of old case, that rule overrides the general survival protocols of Section 6. But what if the law is completely silent on a transitional issue? Indian jurisprudence follows a classic directive for these moments. A judge must not alter the material of which a statute is woven, but they can and should iron out the creases. Judges cannot rewrite a poorly drafted law. Instead, they use presumptions of correctness and legislative intent to smooth over technical glitches and make the transition functional. In the statutory system, judges act as mechanics. They are tasked with keeping the engine running, not redesigning the machine. Zooming out, we can see the macro-level reality of the Indian legal system today. The transition from the IPC to the BNS creates a decades-long overlapping splice. As the IPC timeline terminates, it shatters into thousands of fading threads as old trials slowly close. Indian courts will try IPC cases and BNS cases simultaneously for years to come. This dual-track reality illustrates Roscoe Pound's theory of social engineering. Pound defined law as a tool used to build an efficient society by balancing competing interests with minimum friction. The repeal paradox forces a balance between the interest in a modernized penal code and the need for legal certainty regarding past wrongs. Section 6 of the General Clauses Act functions as a tool of social engineering, managing the friction of this transition to ensure systemic stability. A repeal is largely a legislative illusion. Removing a law from the books prevents it from acquiring new targets, but it does not sever its grip on those already caught in its web. The statutory framework maintains procedural continuity even during total modernization. A statute may be struck down, but its legal force survives exactly as long as necessary to settle every debt incurred under its watch. In the eyes of the law, true extinction only occurs when the final case is closed.